Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Mashegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Well, that wasn't a very long break, was it? No, it wasn't. We've got the decisions on everything is like tilted here. We've got the decisions on the some of the motions that were heard yesterday. But what is intriguing me a bit more, thank you, Andrea, for sending this to me, is a story that just broke on Boston 25. So let's bring that up first. No spoilers, please. I'm a little bit surprised by this. If you guys are on the cesspool of Twitter or you watch the Yellow Cottage Cheese, you may have heard that he was reporting yesterday that the federal investigation of the Karen Read case is over based on these, quote, sources. I know, I was about to go out. I did, Mystery and Eddie. So let's just take a look at this, okay? Because this strains my credulity. I don't know who these sources are, but here's what, as of a half an hour ago, this is what Ted Daniel is reporting on Boston 25. It says 25 investigates, federal investigation of Karen Read case is over. Sources say. Sources say. Who are the sources? Kevin, I don't even know his last name. Kevin from the Cottage Cheese? Okay, let's see if they name their sources. So this was just posted at 2 p.m. today, February 24th, by Ted Daniel. And it says 2 sources briefed on conversations that occurred between the U.S. Attorney's Office in Boston and state and local law enforcement tell 25 investigates that the federal probe of the Karen Read murder case has officially ended. Who are the sources? Please tell me they're not getting their information from Twitter. Please tell me, Ted Daniel, that you vetted this source and that you have better sources than this. Is this like intentional bad press coming out before tomorrow's annihilation of Hank Brennan? I hope that's what it is. But it goes on to say the case centers on the death of Boston police officer John O'Keefe. Both sources who spoke on the condition of anonymity said federal prosecutors notified Massachusetts State Police, the Norfolk District Attorney's Office, and the Canton Police Department last week that no charges would be filed. Well, how did Kevin Linehan know that yesterday? Does he have a direct line to these alleged sources? Is it really true? I don't know, but this is wild. One source said they expect Norfolk County Special Prosecutor Hank Brennan to announce the development when Reed returns to court Tuesday, meaning tomorrow, for the continuation of a pretrial hearing that Judge Beverly Cannoni abruptly ended last week. I mean, do they notify people when the investigation is over? And they're saying that they notified. How do I get these stupid pop-ups out of here? They notified the district attorney's office and the MSP and the Canton PD that no charges would be filed. They expect Hank Brennan to announce it tomorrow. So guess what they did? They just stole his thunder. They just stole his thunder. Ted Daniels stole Hank Brennan's thunder. Oh, yes, oh, yes, oh, yes, he did, if it's true. As 25 Investigates reported in December 2023, the federal probe was run by the U.S. Attorney's Public Corruption Unit, and agents from the Boston FBI office assisted with it. It was focused on widely publicized allegations that Reed was framed for O'Keefe's death by law enforcement and those she and O'Keefe had been drinking with in the hours before O'Keefe was found unresponsive outside 34 Fairview Road in Canton on the morning of January 29th, 2022. Multiple people were questioned before a federal grand jury, including the state police detectives who arrested Reed, along with witnesses for the prosecution. Can I get these pop-offs out of here? What the duck, man? Hold on. It's like their website. Okay, they're not going to let me X that out. So it is what it is for now. The federal government provided 3,074 pages of documents from their investigation of Reed's case before her trial last April in Dedham's Norfolk Superior Court. The documents included Trooper Michael Proctor's offensive text messages about Reed, grand jury testimony from prosecution witness Brian Higgins about the destruction of his cell phone, and findings from ARCA, an engineering consulting firm that concluded that O'Keefe's injuries did not appear to come from a vehicle strike. Reed is charged with second-degree murder and other charges. The Norfolk DA's office alleges she struck O'Keefe with her SUV while driving in reverse. The conclusion of the federal probe comes 1 month after new U.S. Attorney for the District of Massachusetts, Leah Foley, was appointed to replace Josh Levy, who resigned on January 17th, 2025. 25 Investigates reached out to the Norfolk DA's office, state police, Canton Police Chief Helena Rafferty. None immediately responded. Okay, so they have no information from the DA's office, the police, the Canton Police Chief. None of them responded, but you're going to go with alleged sources who told you this information and then publish this worldwide? Okay, I guess. Mainstream media, my friends, mainstream media. 25 Investigates reached out to all of them and none of them would respond, but we're going to go out and publish this anyway. Reed's defense and the U.S. Attorney's Office declined to comment. Boston 25 will stream Tuesday's court hearing. This is a developing story. Check back for updates as more information becomes available and or a retraction. Wow. Wow. So if you're just tuning in, Boston 25 is reporting, according to their quote sources, end quote, the federal investigation of Karen Reed case is over, say their quote sources. Sources are trust me, bro. Two sources who only spoke to them on condition of anonymity. And this is Ted Daniel reporting. There's no video yet because it just broke like 20 minutes ago. Must be a slow news day. No, they're getting this out there intentionally before tomorrow's hearing, and they are saying that Hank Brennan is expected to announce it tomorrow at the hearing, and so they stole Hank Brennan's thunder. If this is true, I mean, does the federal government does the FBI tell people when Thank you, Scott. Scott, you changed your name back. Live from a yellow attic. I'm sorry, attic. Wow, just wow. Wow, just wow. I don't know if they're getting their sources from Twitter or what. A lot of people don't believe it. I am just telling you that She Rage Knits says, I trust Ted Daniels did his due diligence, but he can only know what he's told. And Facts Matters coming in with the 20 to say this is not how the feds operate. His or her uncle was a SIC. So, I don't know. Thanks for your super chat. I guess we'll see. I guess. So, thank you, Andrea, for sending that to me. And we're on top of it. We're on top of the breaking news. You heard it here first, maybe, unless it's been out there. I was happy. I thought Ted Daniels' interview of Karen Reed and Alan Jackson was great. Now I have concerns about his reporting if this actually turns out not to be true. Yeah, I said I would go live. I know you just finished the other one. I said I would go live as soon as I had a copy of the judge's order. And we have a copy of the judge's order reporting on some of the making some of her decisions last week from last week's hearing. So we've got that. But you know, what the duck? This is docket number 518. Hold on a minute, because I need to pull up the motions that they are going to refer to so that we can, let me just get my ducks in a row. Let me get my ducks in a row here, peeps. Yeah, we'll find out when there's an indictment. I don't know. Won't we find out when there's an indictment, Gen X chick? I don't know. Just saying. Hang on. And if it is true, it's true. But I would say that if he's reporting this without sources, I think that's just odd that he would print something like this, or Boston 25 would publish something like this without any official verification. People are saying it's to taint the jury. Everyone's reporting it. Is anyone surprised? I mean, Bias Bev says the feds usually go on a live conference to the media when their decision is on this public case. I mean, I don't know. So there's that. Maybe they're out making arrests right now. I don't know. I have no idea. Joe needs to clear his chakras, clear all the chakras. So there's that. You heard it here first. We'll see what else pops in the meantime. But in the meantime, let's get to the judge's order on the motions that were heard on February 18th, which was last Tuesday. And the first one is paper number 483. Paper number 483, which was the motion to compel the turning over of the video surveillance camera footage from Canton Sallyport. Hold on, 483. That was the motion to compel the production of a forensically sound copy of the Canton Sallyport video footage from January 29th, pursuant to Brady. This is concerning the metadata concerning the retired Canton PD detectives. First, it was his iCloud, and then it was his computer, and then it was a hard drive, and then all the defense wants is the metadata. They want the metadata, and that is when I think Hank Brennan said, "We can't give you something that doesn't exist. Should we just make up something that doesn't exist?" Well, here's what the judge says. In her rulings on motions heard on February 18th, 2025, defendant's motion to compel video surveillance, paper number 483. Motion is denied. Sorry, you can't have the metadata. Sorry. Here's the reasoning. The Commonwealth is to comply with Massachusetts Rule of Criminal Procedure 14B1, effective March 1, 2025. There are new rules coming into effect on March 1st. And guess who sat on the committee to draft these new rules? Yep, you guessed it, Judge Cannoni. They're not taking effect until March 1, but, you know, she's going to cite them. Today's only February 24th. Which provides in pertinent part that the prosecutor shall permit the defense to discover, inspect, and copy all photographs, video, and audio recordings in possession of the prosecution team. After hearing on February 6, 2025, that was the, I guess, second to last hearing that we did, the parties reached an agreement that the Commonwealth would have a member of the prosecution team copy any surveillance video in the detective file, store the materials on a hard drive, and then produce a copy to the defense. Though this is the old click and drag, not a big whoop, right? Brennan said at the when they argued this on last Tuesday, you know, it's just a click and drag. It's not a big deal. Don't know if there's metadata. Don't know. Nick Rocco says, not saying it's true, but if it was true, I think they would release something to the press. Yeah, don't you think they would do like a press conference or put something up on the FBI website or tweet it, or I don't know. Would they Well, apparently Ted Daniel got the hot take from unnamed sources, and maybe he's getting his information from people who talked about it on YouTube or Twitter. I don't know. I don't know. Nick, I'm confused, but it is what it is at this point, as far as the reporting goes. Okay, so after the hearing on February 6th, the parties reached an agreement that the Commonwealth would have a member of the prosecution team copy any surveillance video in the detective file, store the materials on a hard drive, and then produce a copy to the defense. The process would be video recorded. There is no affidavit or of an expert or any evidence before the court that the procedure agreed to by the skilled counsel for both parties. Oh, she's throwing shade now because Alan Jackson came in and said, Your Honor, they told us it was in a cloud somewhere, and now they tell us it's on a hard drive somewhere, and we need to find out if there's metadata. And now here she is. They went in a conference room, and then remember that Brennan was throwing shade because Ms. Little was not at this little meeting that they had in the back conference room, and yet she was the one writing emails about it. How dare she? And so there's no affidavit of an expert or any evidence before the court that the procedure agreed to by the skilled counsel for both parties would result in the destruction of metadata. The process agreed to by the parties satisfies Rule 14b, 1G, and complies with the court order of October 5th of 2023 before the first trial. Okay? Okay? You're not entitled to the metadata. You agreed. You met and conferred after that conference on February 6th. I don't care that you found out now that it's not what you thought it was, because this is good enough. It's good enough. Look the other way. This is good enough. You don't need metadata. You don't need to know whether this stuff was altered, destroyed, recreated. You don't need to know about any of that Canton Sallyport video. You don't need to know what was hidden from you. You don't need to know what was deleted. You don't need to know any of that stuff, because the Commonwealth is entitled to a fair trial. I'm going to go berserk. My head is going to pop off. My head is going to pop off. They had the murder weapon, the alleged murder weapon, the vehicle of Karen Read, in their custody, possession, and control since January 29th of 2022, when they ordered for it to be towed from her parents' house in Dighton without ever knowing if there was a cracked taillight, without ever taking a picture of the ducking thing. They knew that it was the murder weapon. And they just decided not to hang on to all of that Canton Sallyport video for 24-hour period after it got there. Really? Really? Okay. If you have ever been in denial about, or thought that you might want to give this judge the benefit of the doubt in some way, shape, or form, such as I did, have no doubt, my friends, have no doubt about what's going on here. I mean, all of a sudden, Ted Daniel is breaking a story that the federal investigation is over. And now, oh, we don't have to watch out anymore. Nobody's looking over our shoulder, maybe. And so we're just going to release this order today that you don't need no metadata. You don't need it. It's good enough. Look the other way. All your doubts and fears have now been allayed. Here it is in black and white. Corruption in plain sight. Are you outraged? Massachusetts residents, blink if you need help. Blink if you need help. Here's the ruling on the motion for the pro hoc vice, motion for admission pro hoc vice of Mark Betterow. The affidavit of counsel is insufficient. Attorney Yannetti will provide an additional affidavit. Motion under advisement. Defendant's motion to compel discovery. This is paper number 495. Let me pull it up so that I have a copy of it. You know, the click and drag is good enough, my friends. The click and drag is good enough. We are in the upside down, the Matrix, Narnia, Lion, the Witch, and the Wardrobe. We're there. We're officially there. We're so deep into there that it's absolute insanity. This is paper number response or decision on paper 495. which is the defendant's motion to compel discovery. And this is defense request number 1, which is they want a chain of custody logs, reports, evidence logs, and other documentation regarding how the district attorney's office and/or state police came into possession of each distinct production of video surveillance footage from the Canton PD that has been provided to the defense. And the ruling on that motion is allowed in part and denied in part. The Commonwealth has agreed, and the court orders production of the investigative materials sought in the possession, custody, or control of the prosecution team. The Commonwealth has an ongoing obligation to provide items and information favorable to the defense. There is no requirement under Rule 14 that the Commonwealth create items that do not current. It says do not current exist, probably means do not currently exist. That is citing a 1999 case from Commonwealth v. Beal. So you don't get it. No chain of custody logs, no reports or evidence logs or any other documentation about how each portion of video surveillance footage from the Canton PD that you've turned over in a trickle to us has been provided. And I said this earlier this morning. I said, okay, you're denying that? You're going to deny that? Let's call them all in. We need an evidentiary hearing, Your Honor. We need an evidentiary hearing. Here's who we need to call as our witnesses. Police Chief Helena Rafferty, Tully, Fanning, whoever had their fingers on any of this stuff. Proctor, Buchanan, Lally. Mr. Lally, you might now become a witness because we need to know where all of these videos came from, who had possession of them, who had custody and control of them, who touched them, and how they got finally into defense's possession, but most of them weren't turned over to the defense until after the trial was over. Isn't that curious? After the trial was over. You don't want to tell us how you got them? Good. Let's call everybody in. Let's have an evidentiary hearing. Defense requests numbers 2, 3, and 4. Denied without prejudice. Okay, here's what 2, 3, and 4 were. Number 2 is the unredacted copy of the investigation into the death of Sandra Birchmore, the MSP report number 26. And remember, because we went over this at least twice, the investigation into the death of Sandra Birchmore has involved many of the material witnesses in Karen Reed's case, including, but not limited to, Sergeant Michael Lank, the friendly, who was the first on scene and the first to go into the Albert home at 34 Fairview, the guy whose house Jennifer McCabe went over to with Carrie Roberts to allegedly drop off Carrie Roberts' kid because the kid was a friend of Lank's kid. And then the wife, I think, came out to the car to talk to them. And she doesn't really remember, but she might have gone in there to go to the bathroom. But they sat out there in a freezing cold car for 45 minutes because somehow somebody found out that Jennifer McCabe went to Lank's house either the day after January 29th. I don't remember the exact date. Does anybody know the exact day? Because the location data was in Life 360, and the defense did have that, as did the prosecution, but the defense was required to turn over that impeachment evidence to the prosecution. So therefore, Jennifer McCabe knew that question was coming and didn't bring it up until her cross-examination when she finally admitted that she did go to Michael Lank's house, but she didn't see him. She just saw the wife. Because, Carrie Roberts and her were good friends, and all of a sudden they were in the car together going over to Lank's house. Michael Lank, that's who Michael Lank is. Daniel Whitley, Trooper Mike Dunn, Trooper Zach Clark, Colleen Crawford, Detective Kevin Albert, Lieutenant John Fanning, Trooper Garino, Lieutenant Brian Tully, Deputy District Attorney Lynn Beland, and District Attorney Michael Marcy. Well, Her Honor does not have enough information whether she can determine whether or not that's relevant. So she goes on to say that the court also understands that the materials sought may be protected under a federal protective order. Well, I don't know if the Sandra Birchmore reports are. Maybe you guys know. Maybe if Mizzy's here, maybe Mizzy knows. Counsel are free to file supplemental memoranda and or provide the court with the redacted version that both parties have in their possession, provided doing so is not a violation of any federal protective order. So you can file more papers, spend more money, more time. We'll take up more court time with this, but I'm not going to give you them right now. You can come back and ask me again later. This is what they want. They want the unredacted police report regarding the investigation of the death of Sandra Birchmore. That is request number 2. Request number 3 is an unredacted copy of the public record response relating to all email correspondence and communications associated with the Sandra Birchmore investigation. And they went into this in great lengths in their motion that we have read. That was docket number 495. For that one, Attorney Brennan told them go to the U.S. Attorney's Office for that. However, the argument back to them is if it's in your custody, possession, and control, and you have an unredacted copy, you need to turn it over. And then defense request number 4 was an unredacted copy of all reports, communications, handwritten law enforcement notes, and or other documents from the Sandra Birchmore case or investigation concerning material law enforcement witnesses in this case. And they name, again, those same people that we just named and say that, and we've talked about this before too, that because certain people like Nicholas Garino, aka Trooperino, was involved in the investigation of the murder, which we now know is a murder of Sandra Birchmore, and he was not able to find 32,000 text messages on Farwell's phone between Farwell and Sandra Birchmore, and that he also investigated or examined some of the cellular forensics in the murder of Officer John O'Keefe, that perhaps he's a little bit biased, compromised, and or incompetent. And so we should be entitled to those materials too, but no, they're not, apparently, unless they make another application and a better showing. So obviously those would also go to impeachment, any of those materials. Fanning was the lead investigator in the Sandra Birchmore investigation, and also apparently was in charge of the Karen Reed jury. So there's that. But no, you can't have that either. Nope. Look the other way, everyone. Look the other way. Birchmore has nothing to do with Karen Reed, but come back with some more information if you so choose. Defense request number 5 is denied. Request number 5 is the request for all communications, documents, reports, memoranda, recordings of interviews, physical evidence, findings, and or other evidence relating to the internal affairs investigation of Trooper Michael Proctor, including transcripts of the administrative proceedings. And the judge, Canoni, says, denied. This requested discovery is outside the scope of Rule 14. Nope, can't have it. Can't have it. Nothing to see here, folks. Look the other way. Despite the fact that Elizabeth Little pointed out that if a prosecutor, there is Supreme Judicial Court precedent that says if a prosecutor has possession or control of the records of an investigation by an internal affairs division of a police department with respect to a particular matter, the prosecutor must review that material in response to a Rule 14 motion for the production of exculpatory facts. That is a case called Commonwealth v. Wannis from 1998. And they have an obligation to turn it over, but the judge says, nope, outside the scope, you can't have it. We don't care if Michael Proctor did anything. You're not getting it. Not getting it. Defense requests 6 and 7 are allowed by agreement. That was communications between law enforcement and witnesses in this case, including but not limited to Yuri Buchanan and Chris Albert. We went over that at length in a couple of other streams. That has been allowed by agreement, as has number 7, which is all notes and correspondence regarding any testing conducted in this case, along with all research and materials relied upon by the Commonwealth's experts in completing their analysis regardless of whether the witnesses will be testifying at trial. And that is agreed to. So judge didn't have to rule on that. And this is defense request 8 and 9. 8 is a demand for all communications between members of the Norfolk County DA's office and or its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and list of materials received. And I think this may be the demand that Ms. Little, no relation, said. It's funny that Mr. Brennan is objecting to this demand because it is copied word for word from the demand he served upon us. So that's interesting. I think. Is that the right? I think that's what it is. And so that is denied in part as overbroad. And she says, and number 9 was all written communications, including emails and text messages between any member of Norfolk County DA's office and or law enforcement agents and any expert witnesses the Commonwealth intends to call at trial, and so that they can prepare for cross-examination of the experts. And the judge says, denied in part is overbroad. The Commonwealth must provide discovery consistent with their obligations under new Rule 14A, 14B, and 14.2. Rule 14.2F, definition of work product does not include any items or information that the prosecutor is obligated to disclose as items or information favorable to the defense. The court is satisfied that the written response of the Commonwealth indicates the Commonwealth's understanding of its discovery obligations as outlined in the rule and the reporter's notes to the rule and of its continuing duty. So trust me, bro, is good enough. Good enough. But again, can't use it as a shield and a sword. You can't say it's good enough for them, but the defense is going to be required to turn over a whole bunch of other things and stuff. So there's that. And then there's defense request number 10, which is allowed by agreement. And defense request number 10 is a legible copy of a series of text messages that the Commonwealth provided to the defense. We don't know who they're between, but they're illegible. And so apparently that was agreed to. And then therefore the court decided that that's good enough. But XOXO, dated today, February 24th, 2025. XOXO, Beverly J. Cannoni, Justice of the Supreme Court. Nope. No metadata for you. No metadata for you. Sorry. It's good enough. Look the other way. But again, as I said many, many times, and I'm going to repeat it a little bit louder for those in the back, this could lead to an evidentiary hearing in which many, many people will be called in as witnesses to testify about how they came into possession of that Kate and Sally Port video, where it's been, why it wasn't turned over originally, and things as such. What is that? Well, after all this, what will happen tomorrow? Tomorrow really wasn't going to have anything to do with this anyway. Tomorrow has to do with the grave concerns that Judge Cannoni had last week that caused her to suspend the hearing and call everybody back for tomorrow regarding the alleged improprieties of defense counsel in failing to turn over communications with ARCA experts, but actually it was the defense who turned over theirs communications, not the feds. So we'll see what happens tomorrow. Back to the chat for a moment. The whole world calls me Hank. Thanks for your 50. Says, how long would this ducking be allowed to continue? How long will it be allowed to continue? I am furious. They have destroyed evidence. The defense must appeal this crap. They are all corrupt. Well, the whole world calls me Hank. We are still waiting. We do not have a copy of the motion to dismiss. Whether it will appear on the docket or not, we don't know. We don't know because the Commonwealth wants everything from this point forward to be impounded so that they and the judge can look at the things together and decide whether or not things should be impounded. That has not been ruled on yet. And so therefore, I don't think she can impound it. We read this morning the defense motion to impound certain portions of the motion to dismiss for extraordinary governmental misconduct and learned that the defense was kind enough to provide a redacted copy of the motion and an unredacted copy. And so therefore, since we know it was filed last Friday, we just do not know if it's been scanned into the system yet. And so we don't have a copy of it. But as soon as we get a copy of it, we're going to see what else is in there and what other reasons they have and whether any of this is going to be brought up in that motion to dismiss for extraordinary governmental misconduct. And I believe it probably will have something to do with this inverted video, the disappearing video, the metadata, the destruction of evidence, the spoliation of evidence. And perhaps they found out some stuff when they got hold of some of the emails of the district attorney. We don't know. And we may never know. We may not know by tomorrow. They're not going to hear that motion tomorrow anyway. It's not going to be argued tomorrow. But again, the whole world calls me Hank. Thanks for coming in with your super chat and for being a very generous contributor to this channel. Improv man, she denied argument. Is there an issue on ruling? I don't know. Well, they did argue this motion in open court, the one that we just went on the ruling for, or the one that we just went on, the one that I just read to you. It was argued in court, so I don't know. I know what you're talking about. Ipsy Dixit. The feds gave 347 pages of discovery and the case went on. Yep, they had it all. Retired detective file. You talking about me? That's you. I love it. I love how you change your username. Retired detective file. That's amazing. Everyone, while you're here, I need you to smash the like button because there's over 6,200 people here. Oh, no, we can't have that. We can't allow it. I'm not going to allow it. There's only 1,400 likes. We got to do better. We got to do better, or, I just I may just end this stream and wait until we get a copy of the motion. We can do better. You may have to close out the chat if you're on your phone to hit the like button, but you're going to do it. But retired detective file is here, has changed his or her username, and it's amazing. Jerry Roth, this is my guess. All Commonwealth approved, all defense denied. Well, you were kind of right on the money, right? What was granted? Nothing was granted here unless it was on agreement. All right. Motion to compel video surveillance, evidence logs and chain of custody. No, denied. You get what you get and you don't get upset like they tell you in preschool. And, there's no affidavit of an expert or any evidence before the court that the procedure agreed to by the skilled counsel for both parties would result in the destruction of metadata. Now she wants affidavits. Pay your expert to write an affidavit because I don't even know what to say. They went from iCloud to hard drive, detective file. The guy who's the retired detective just happened to be there when Hank Brennan went there to check it out. And Hank Brennan said he's never even reviewed the video. He doesn't even know what's in that detective file. He hasn't reviewed it, hasn't looked at it, doesn't know what it is, hasn't been inventoried. Listen, I unless you're in Indiana, in Delphi, I don't even know where else this could even happen. I just don't. Paisley Chicken, no charges because someone flipped to testify on another case. I don't know. Are you saying talking about the FBI? Or some agreement that there would be state charges in lieu of federal? Oh, Paisley Chicken is trying to flip it into a positive. I like it. Well done. Melissa. Hi, Melissa. How can Bev legally deny the defense discovery / evidence? This is making me sick and infuriated. Yep. You're not the only one. Thanks for your super chat. Proctored and doctored is outraged. Thanks for your super chat. Colleen Trish says, Melanie, if in fact a federal investigation is complete, would that mean the federal protective order could or would be lifted? I don't know. Show me the TUI. I don't know if it's complete, if that releases the materials. And I can't opine on something that I'm not exactly sure of the answer to. It's a great question. I just don't want to give you the wrong information. Thanks for your super chat, though. Desert Quill, thanks for the 10. This should scare every fair-minded person since BC, since Judge Cannoni allowed the inverted, undocumented, apparitional video. I had to assume it could only happen if Beverly Cannoni was part of this sham. After this, I know. Good time to point out that my members' opinions are not necessarily my opinions. Thank you for the super chat, Desert Quill. And I think a lot of people feel the same way. Stephanie says Karen will never be convicted. See, she knows how to look for the positive, the silver lining. And John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. And anybody who has any common sense, logic, and or basic skills of common sense will may be able to see that. After that jury interview, I'm not so sure. Piney Woods, Law and Crime, thanks for the 20. This is probably directly related to Mr. Levy's departure and the purges made by the new administration, if it is true at all, talking about the FBI concluding its investigation, according to Boston 25 News. This case is wildly FUBAR. Verklempt. So we're off a climb. We're off a climb. We're off a climb. We're off a climb. Thank you for the 20. Straining of credulity. Oh, I like that username too. I have merch. Thanks for the 5. They're all going to be throwing their gloves off tomorrow. This is going to be, I mean, if you thought tomorrow was going to be fiery, it's going to be like the biggest bonfire you ever saw tomorrow. It's going to be crazy. I agree. Thanks for your super chat. Lisa Thornton, thanks for the 5. So if the feds are done, does that mean their evidence can be unsealed? Yeah, again, thank you again for a great question. Don't especially know the answer. And I don't know that that's exactly true, because think about like the federal investigation into like the assassination of JFK. Like that information was never unsealed. It was just unsealed recently, right? So I don't know the federal rules well enough to know the answer to that question. My gut tells me not necessarily, but I'll have to look into it. Is the best I can do. Kathleen, thank you for the 5. Can the judge deny a request for an evidence hearing? She's the gatekeeper. She can kind of do whatever she wants. So yes, she can. Are there good grounds for an evidentiary hearing? I think so. Again, we're in the upside down matrix world of Narnia. So who knows? Sarah Boone's left kidney is here from Australia and says, I get knocked down, but I get up again. Thank you very much for thinking in song lyrics and via super chat. Nina's here. If no metadata is needed, how does the court know if a video or picture is generated by AI? That's a great question. It's a great question, Nina. I feel you. Irish Wolfhound Mama says, if the feds are supposedly done and there will be no charges, there is no hope for humanity. Never mind for Massachusetts. Like, what the duck? Thank you. Thank you so much for coming in with your super chat. Let us see. For those of you who are emailing me the decision, we've already gone over it. Thank you so very much. For those of you who are emailing me because you're beside yourself, because you're not showing up in the chat, I don't know what that is about. I cannot read emails that are 14 pages long, and I don't understand, and I don't know, and I can't stop my stream to find you on a blocked list somewhere that may have been done by accident and let you in. I'm really sorry, but that's not how live streaming works. Amber says, what a sham, debating what my protest sign will say. Yeah, good, Amber. Good. Anybody have any ideas for protest signs? Put them in the chat. Put them in the chat. People are rage crocheting. Everybody's crazy. Everybody's crazy. There's been no, YouTube has been glitchy. Thank you, Thomas. YouTube has been glitchy. If you cannot super chat, your credit card may have expired. You may have to unsubscribe and then resubscribe. I have my settings set to a certain length for subscribers. If that happens to you, I'm really sorry, but it's just the way it is. Is better allowed? It's been, it hasn't been ruled on. It's under advisement. They want more information from Mr. Yannutti. And also, she said she was going to consider all those things that Hank Brennan got up and said on the record that he didn't put in any papers about, well, I have no opposition, but I would like to tell you my thoughts and hear my thoughts. And we talked about that at length this morning. So if you haven't watched the stream from this morning, you might want to go do that, because we also went over the original order and the original judge's decision on whether or not she should recuse herself. That was decided in the summer of 2023. And it's really interesting for those of you who weren't following this case all the way back during its pretrial days. You may want to check it out, because that decision that was made by Judge Cannoni about whether or not she should recuse herself is very interesting reading. And we went over that at length. Talk amongst yourselves for 1 second, if you don't mind. The world is watching. That's what the sign should say. Great idea, KPT. Great idea. The world is watching. The federal habeas petition, not that I don't know that it got denied. I don't know anything about that. All I know is what the judge decided based on those things that we just went over just now. And that Boston 25, Ted Daniel is reporting that the federal investigation has been over based on unnamed sources that will not reveal themselves. So there's that. Go back and watch it. Okay, Karen Reed's lawyers asked for a motion to dismiss impounded according to masslive.com. Thank you, Lisa, for sending me that information, but that's not accurate. Mass Live is misreporting that because Karen Reed's, we went over this motion this morning. Karen Reed's lawyers made a motion that part of it should be impounded. Part of it that was subject to federal non-disclosure agreements and orders, federal protective orders, and they submitted a redacted copy to the court and an unredacted copy to the court. So if Mass Live is reporting that, it's only parts of the motion to dismiss. Thank you for your email, but that is not exactly accurate there. And so there's that. If the redacted copy is posted to the docket, we'll come back and do that later. So there is that to look forward to. Make sure you hit subscribe, make sure you hit all notifications. And so there's that. All right. So right now I need to go drive the mommy Uber for a little while, but there's about 45 minutes here for you to go back and you can, dang, Mel, you should care more if one of your peeps got accidentally blocked. Of course I care, but I can't stop what I'm doing right this second to go through the list that people are frantically emailing me about. It's not that I don't care, Misty. I do care. I just cannot stop what I'm doing because somebody frantically emails me to go check. I'm sorry, but I'm not sorry. I just can't. Not that I don't care. Just can't stop what I'm doing. But let's why do I, because it's on pause. I'm like, why do I look frozen on my phone? Make sure you have subscriptions set to all or notifications set to all so you can get them. And when I end this stream, it's going to redirect you to the morning stream, which is going to be a little before 11 o'clock for the hearing so that you can hit the notification bell on that one. However, if I do get an a redacted copy of the motion to dismiss, we will come back and cover that at some point after 4 p.m. Eastern. So thank you, mods, for, doing all the things and stuff that you do for me on a daily basis. I appreciate you so much. It's not easy. It's not easy being one of my mods, but you guys rock it. Straining for Credulity says, sign, welcome to Bev's Supreme Court of Corruption. Thanks for your super chat. And Cheryl says, can the defense appeal any of her decisions as in metadata? Yes, they can. Pretty important PC to leave out, especially in this case. Yeah. We're going to see what happens. We're going to see what happens tomorrow. We're going to see if we come back later with the motion to dismiss. So stay tuned, my friends. I always say to end every stream, stay cool, stay kind, stay classy. You guys can do it. Smash the like button on your way out. And of course, on your way in. And when I hit go, when I hit end, it's going to teleport you to tomorrow's stream. Just please hit the notification bell so that you come back tomorrow so we can cover the hearing live together. And the notifications. So, all the things and stuff. Stay cool, stay kind, stay classy. You can do it. I know you can do it. Peace, everyone. May see you later.